I want to talk a little bit about electronic monitoring. This is an area within our community programs. So one of our divisions, we have 4 divisions. It's the Administration and Programs Division. And within that division, we run community programs, which is a program within our department that provides services post-incarceration. Specifically, electronic monitoring is a level of supervision. So an individual is incarcerated, a judicial officer releases them on their own recognizance, and that judicial officer may request electronic monitoring as a level of supervision. That's what this data shows. So this data was taken in June of last year, June of 2023, and it's called SNAP data. So at a point in time census in June, we looked at everybody that was on our electronic monitoring program. And what you have before you is the data for that. So 138 people released by the court on electronic monitoring were charged with a serious and violent offense. And those are offenses classified under the law that way. It's not an offense that the sheriff's office picks. Another 149 were classified as other felonies, or what's called excluded felonies. The vast majority of people on our electronic monitoring program are charged with felonies, as the data shows. At that time, there were 3 people charged with murder on electronic monitoring, 6 people with attempted murder, those charged with rape and arson, lewd acts on a child, robbery, and domestic violence. I bring this data up not as a point to scare people, but as an actual data point. There are some individuals out on OR release that are charged with significant crimes, and it is incumbent upon the Office of the Sheriff to monitor those people post-release. And the question is, how do we do that? Well, we do that through real-time monitoring. So we have deputies working 24 hours a day, 7 days a week, monitoring individuals on electronic monitoring. We also do real-time interventions to exclusionary zone violations. So someone may have been released on domestic violence and they have a stay-away order, and then they start to approach the stay-away order. We get an alert at our program site, and then we try and intervene. We do home checks and compliance checks. The other thing we do is we author warrants for presentation to a judge if an individual is not compliant with the orders of the court. Ultimately, it's up to the judge to decide if they want to sign that warrant, but we do write affidavits. We offer it as a proffer of evidence to a judicial officer, and they render a decision. If a judge signs a warrant, we actively go look for the person to return them to secure detention. For last fiscal year, there were 1,323 warrants authored. That is a high number of warrants. Of those, 867 were still outstanding at the time, 51 were recalled, and 405 were served, and the individual was returned to custody. This is important because electronic monitoring is a tool that's used to release people so they can continue to meet the requirements of the court while they're in the community, and many times it's successful, other times it's not. So this is just data that shows the difficulty in supervising people in the community.